Welcome to the second of 3 videos made by BPP University Law School students about what to expect at a final Employment Tribunal hearing. This video covers what happens during the hearing itself, including giving evidence. The day usually starts with the judge speaking to the parties to confirm the identity of the parties and any reps, the type of claims being brought, whether the tribunal has received the correct number of bundles, whether the hearing will deal with liability, remedy, or both, which party will give evidence first, and the running order of the day. The judge will ask if either party wants to raise any matter before the evidence begins. For example, clarification of matters in dispute, admissions, or any disagreements over disclosure. The tribunal may set time limits on the time each party can take in presenting evidence and questioning witnesses. For example, you have 20 minutes for cross-examining each witness. If the judge asks you to state why you are there, you should briefly explain why you are there and what your case is about. For example, my name is Rachel Jones and I am bringing an unfair dismissal complaint against my ex-employer ABC Limited. I am calling 2 witnesses as well as myself to help support my case. The party with the burden of proof usually gives their evidence first. In an unfair dismissal claim, the respondent usually goes first. In constructive dismissal or discrimination cases, the claimant will usually start. The judge does, however, have discretion to decide who goes first.
If your witness is only available at a particular time due to work or childcare commitments, you can request for the tribunal to hear their evidence first. You should try and write to the tribunal and the other side before the hearing if you want to make such a request. All witnesses must give an oath or affirmation. An oath is taken on the holy book appropriate to your faith. Alternatively, an affirmation is a solemn civil promise not linked to religious belief. Everyone present in the tribunal room should be silent while the oath or affirmation is spoken. All witness statements must be prepared in advance. Statements are generally taken as read, which means you do not need to read its contents out loud. The judge is usually given time to read witness statements before the hearing starts, or will call a short break at the beginning of the hearing to do so. When you are in the witness box, the judge will ask you to confirm your name and address, and to confirm that the witness statement placed on the table in front of you is yours and is true to the best of your knowledge and belief. If you have a rep, they may ask you supplementary questions. You should stay seated for cross-examination. The judge may also ask you questions. If new matters arise in cross-examination, you or your rep may clarify these in re-examination. The judge will then ask you to return to your seat.
Address your answers to the judge, as that's the person deciding your case. People are allowed to enter and leave the room during the hearing, so don't be distracted by this. There is a clean copy of your statement and the bundle of documents on the table in front of you, which you may refer to when giving answers. The judge will be making notes on your answers, so speak slowly and clearly and make sure they finish making notes before moving on to the next question. It's okay to ask for a moment's pause while you find a document in the bundle or are recollecting your thoughts.
If you take a break while giving evidence for lunch or for any other reason, remember you'll still be under oath. You're not allowed to speak to your representative or to any of the witnesses about your evidence or make any phone calls. The judge will remind you of this. The purpose of cross-examination is to obtain evidence favorable to the party asking the question. The other side's representative may challenge things in your statement. Some tips for giving evidence are: be respectful of the other party and answer all questions as accurately as you can. Do not argue with them. Listen carefully to each question, and if you do not agree with something, tell the other party you do not agree. If you did not hear or understand something you were asked, ask the other party to repeat what they said or to explain or say it in a different way. If you do not know the answer to your question, tell the other party you do not know.
Now you know the typical running order of an employment tribunal hearing, head over to our third video to find out what happens at the end of a hearing.
Created using Powtoon.